Okay. Go.
Hand me my screen box. Now go free.
An issue that came up with Mr. Benz last week that I put on for today. This is the case of Joe Burnett versus Gregory Boyd. So, Mr. Boyd, I did review the law and it's what I thought, that your judge in circuit court is correct that you didn't need to pay any money in order to keep your appeal in circuit current.
Yes, ma'am.
But if you don't want the set out order, you must pay all of the rent, okay? So because you haven't paid any rent into the circuit court, we can go forward on the warrant for possession. So I'm going to sign that.
Well, Your Honor,
Yes, sir.
I found my response. I told you that
I have it.
He did not submit me a response within adequate time. I got the response tonight. I came to court the next morning. I never get the chance to respond to it.
Okay.
And I argue in my response that this court lack of subject jurisdiction matter while the matter is
That's
pending.
not true. This court retains subject matter jurisdiction over writ of possessions, even though the underlying case is on appeals.
And I would ask the court to give me a time, set a time for me to work with the circuit court, pay the bond.
You've had time to pay, and it requires that you pay your rent as it is due and owing. So you would have had to pay it on each month as it became due, and you haven't done that. So there's no way to fix it at this point.
Your Honor, I'm renting to own. I spent $40,000 on that property. You don't know the full story, Your Honor. Mr. Burnett want me to pay for city code violation. It's not about I refuse to pay rent. I refuse to pay for city code violation, which is not part of it.
So that is part of your circuit court case, okay?
Yeah, well, that's the reason why we're here today. That's all I'm saying. It's not like I refuse to pay the bond. So I was I appeal it because I do not owe the city no fine, and he don't want to pay. I spent $1,500 fix the pouch. He's supposed to go to court. He never go to court. He want me to pay that money with my rent, and it's not part of the rent agreement. So he's the one who violated the tenant and landlord agreement.
All right, I gave you time on this so I could review the law to make sure correct. We're finished. Thank you.
So okay, so I could appeal this today.
Sir, I can't give you legal advice, okay?
Okay, so
Thank you.
but
Thank you, Your Honor.
I have a right to appeal the decision. No.
Goodbye. How about McDean Road LLC, The Foundry versus Shatira Sloss?
Good afternoon, Your Honor. Katie Harvey here on behalf of the plaintiff.
Okay,
Your Honor, Danny Matlock for the defendant.
and this is going to be a hearing today?
Judge, we got a pre-sentence motion to dismiss.
Okay, what's the pretrial motion to dismiss?
Your Honor, may I approach with?
Uh-huh.
Your Honor, if you look on the complaint, the plaintiff claims they gave my client written notice on January 25th.
Okay,
And the complaint claims this is for material breach of lease for non-certification,
okay.
recertification, excuse me, Judge.
Mm-hmm.
If you flip to the second page in the packet, Judge, she was given a 60-day notice of recertification that provided she has until March 1st, 2024 to recertify. So it seems, I'm a little confused as to how they can proceed on an eviction to, based on failure to recertify and give her a notice on January 25th when she had until March 1st to do so.
Ms. Harvey, do you want to answer that?
Yes, so each of the 4 notices that was provided to Ms. Sloss clearly state that if she were to remain in the unit after March 1st without completing recertification, that would amount to a material breach. So it's not our position that she materially breached when she was sent this notice or one of many notices. It was simply emphasizing to her that if she did not recertify by March 1st, then that would amount to a breach.
Your Honor, it's my understanding that if you didn't recertify until March 31st, you then would have to have a 14-day notice to remedy that situation. If this is a material breach, you'd have to have 14 days to cure. So providing a written notice as of January 25th, 2024 to say she's in material breach of the lease, and it's not even March 2nd yet, she's not in material breach of any lease.
Again, every single notice emphasizes that March 1st is the deadline. So our position is that these notices gave her adequate notice that she had until March 1st to recertify. It made it very clear that if she were to remain in the unit after March 1st, that's when eviction proceedings would be initiated. And that's what happened in this case.
I don't think the issue is with the notice to recertify. I think the issue is that you filed notice to vacate on January 25th, which is clearly before the time frame which you gave her to recertify. How can you tell her she has until March 1st and go ahead and file an eviction on her in January?
I believe that was a different case.
Who's talking?
That is Sabrina Gorman, the property manager.
Okay, well, the forcible detainer complaint, paragraph 6 says, plaintiff gave defendant written notice to vacate on January 25th, 2024.
Your Honor, do you have the January 25th notice in front of you?
No, Judge, you do not. I did not get a copy of it.
If you want, I can share my screen so that I can show this to the court and you can see the language that it provides.
This may have been a notice that she needs to recertify, but the statute is pretty clear on non-financial breaches. You then must have a 14-day notice to remedy the issue. So you can try to say that this is wrapped up in there, that she had 30 days, but she's not actually in breach until March 2nd. Therefore, you would then have to provide her a 14-day remedy notice. And if she doesn't, then you can file. This is premature and this is not appropriate under your Alta, Judge.
Ms. Harvey, would you like to respond?
Your Honor, I would just emphasize that this March 1st deadline was provided to the tenant on 4 different occasions. Her lease also very clearly demonstrates that recertification annually is required. So our position remains that she was on adequate notice that eviction proceedings would be initiated after March 1st.
Right. The problem is you started them before March 1st. That's the whole problem. Had you started eviction proceedings on March 2nd, had she failed, we would have no problems. The problem is you gave her a notice to vacate on January 25th, and I think that's where the problem is. And I think Mr. Matlock is correct that you have confused the two issues. And I think obviously failure to recertify is grounds for an eviction, and your notice for recertification is proper. It's that you went ahead and filed notice of the intent to vacate or the notice to vacate on January 25th. And I think that's the problem. So I agree with Mr. Matlock that this was not timely filed. I think it was confused. I don't think the right to cure is in your January 25th letter as is required under the law. And it's way premature. I think had you sent that letter on March 2nd with a 14-day right to cure, Mr. Matlock would not have an argument, but he didn't. So this case is dismissed.
Judge, it's time for the point to a Bosnian Express.
Okay.
And Your Honor, I make a pretrial motion to dismiss. I don't believe he's an attorney, and he had filed this on behalf of an LLC with his personal signature on it, Mr. Tahirovic.
The complaint was filed by Abbas Tahirovic, and on behalf of a Bosnian Express LLC. And are you Mr. Tahirovic?
Yes.
Are you an attorney?
No.
Okay, this case is dismissed.
Thank you.
Patrick Thomas versus I'm not sure, Lawrence Hall.
Danny Matlock for that.
Help me, how do you say it?
Janaeus, maybe?
Oh, is there an S?
Oh, Janaea? No. Why I always say Miss Hall.
How do you say your first name?
My name's Patrick.
This is
Never mind. How do you say your tenant's first name? Do you know? Jania? Okay, thank you. And is your client on Zoom? Maybe?
Maybe, Judge? We have a pre-trial motion to
Okay,
dismiss.
go ahead.
May I approach, Judge?
Mhm.
First page is the complaint, Judge. Second page is,
Okay.
excuse
Can
me.
whoever is on Zoom who's not on mute, please put themselves on mute?
Down at the second page is the written notice. As you can see, it does
Yeah.
not comply with Uralta. It just says this serves as 7-day notice to vacate property due to non-payment.
Yeah. Sir, this doesn't do what you need to do, okay? It doesn't follow the law.
Your Honor, I have instructions from the sheriff's department, giving it very plain that I follow the guidelines to file a 7-day eviction.
Uh-huh,
And I had a certified letter of receipt.
okay. Well, tell me what the sheriff said about the 7-day letter.
7-day notice to evict for non-payment is really all you have to say. Write a letter stating that they have 7 days to vacate the property for non-payment. That all the letter has to say. Then send the letter certified mail to the address of the property. Keep the receipt as your posted from your post office.
Well, guess what? The sheriffs aren't lawyers either, okay?
So those instructions work properly.
I
Not
don't,
completely.
no, I mean, it's close, but the problem is she has to be given the 7 days to pay in full or vacate. Okay? You need a lawyer, not a sheriff, okay? And if you don't follow the law, I have to dismiss it because it's improper, and it is improper. So you have to start over with correct notice. Or you start over with an attorney from the beginning who can do it correctly, but you didn't do it correctly
She has the right to stay in the property until
until you get it right. Yes, sir. She sure does.
thank you.
Uh-huh. Maurice Welch versus Terralona Smith.
Danny Matlock from Ms. Smith. How you doing?
Partially good. There's a copy for you. Judge, Mike Lawrence on behalf of, Mr. Welch. We would like, Mayor,
Yes, absolutely.
we'd like to substitute the real party interest, which is due date properties number 1, pursuant to CR 1701, 21, and 2503. I believe we can do so and proceed.
Your Honor, this motion, this eviction was filed under Maurice Welch's name. He's not a practicing attorney. He signed it. The true real party in interest is in fact what he's trying to substitute under motion. But summary proceeding courts do not allow it.
Yeah,
Actually, Judge,
go ahead.
motions to substitute real parties in interest are preferred by the courts. We're not trying, Mr., if you look at some of the attachments there, Mr. and Mrs. Welch won,
Okay.
got transferred, it
Okay.
went back and forth. And all we're trying to do is get the real party in interest in there, and that's number 1. New Day Properties number 1. So
Who owns the property?
New Day Properties number 1, which is why we are trying to substitute the real party in interest under CRs 1701, 21, and 2503 that allow the substitution of the real party in interest.
At the time of filing, did New Day Properties own the property?
No, Judge, this has not been owned by the Welches. I'm sorry. The Welches have owned this property since 2006.
Okay, if the Welches own the property,
I'm sorry, New Day, new property. New Day has owned the property since 2006.
Okay, so this isn't a recent transfer.
No.
Is that right?
That is correct,
Okay.
but it's one of several transfers back and forth between Mr. Welch and his wife, a New Day, and back, and I've attached the deeds going back and forth,
Okay.
and this was not an intentional error on the part of Mr. Welch. Accordingly, CR 17, 21, and 25 allow us to substitute the real party of interest in interest because it's not going to negatively affect the defendant. Right? Either way, okay, she might have an extra month, but the only difference is I go down the whole and refile it.
Sure. Well, I
That's a
mean,
big difference in order.
that's a big
for my
difference,
client.
right? Sure.
Okay, but she's already had 5 months and hadn't done anything
Well, your client didn't file this until recently, so that's not my client's fault.
recently. Right, he gave her 5 months before he filed it. She went to housing assistance and she failed to comply. She didn't show up for her meetings in December. So 4 months ago, she could have fixed this and she didn't. Has she done it yet? Has she got a?
Yeah, that, your client's decision to not bring this until now is not my fault nor my client's fault.
Okay,
I
by
mean,
the same token,
if you two want to work out an agreement, that's fine. I have never, ever allowed substitution of parties, ever, in these summary proceedings. I've never allowed it. So I'm not gonna grant your motion. If you two want to work out an agreement where she agrees to vacate in a month or 2 months, that's fine. If that's something you all are willing to, if you're willing to entertain that, you and your client, Mr. Matlock, then I'm gonna deny your motion today unless you all want to try and work something out.
Your Honor, I would move with dismissing the case and I'd certainly contact him after the fact.
Okay, I will dismiss the case then if your client isn't interested in that. Your client, Ms. Hall, joined right after. Ms. Hall, your case was dismissed because your landlord didn't follow the law as he was supposed to. But he will refile, so you should probably be ready to move.
Judge,
Hey, I'm sorry. Can you please repeat that? I heard you a little bit, but I really didn't hear you. I'm so sorry.
Ms. Hall, I will give you a call after court, okay? This is your return.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're gonna start bringing people in person. People are gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm going to these drinks.